Okay. Um, all right, so are you Kendrick O'Veal?
Yes, ma'am.
You are charged with evading arrest or detention with previous conviction, and that's from August 31st of 2025. That shows that you were previously convicted of evading arrest or detention July 22nd of 2011. So that's what makes it a state jail felony. Then the indictment further alleges you were convicted of attempted robbery, a third-degree felony, March 28th of 2013. And after that was final, you were convicted of assault, a third-degree felony, September 11th of 2019. And so what that means in that case is that if you go to trial and you're found guilty, and those prior convictions are true, the range of punishment would be enhanced to a second.
Pause right there. This is where things start escalating fast. What began as a state jail felony just got bumped up because of prior convictions. That's called a punishment enhancement. And in Texas, priors don't just follow you, they amplify everything. So instead of facing a lighter sentence, he's now staring at 2 to 20 years if convicted. And we're just getting started. Ask yourself, if you're hearing that in open court, are you thinking trial or deal?
Degree felony, which is between 2 years and up to 20 years. Do you understand?
Yeah.
And then in cause number 25 DCCR 1777, you're charged with unlawful possession of a firearm by felon. And that is from August 31st of 2025. That indictment alleges one prior felony conviction, the one from 2019, but the state can file, and I anticipate they would file a notice of enhancement because that 2013 was left off of that indictment. And so what that means in that case is if you're found guilty and if those prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years in prison, up to 99 years or the rest.
Did you catch that? 25 to 99 years, or life. That's habitual offender territory. This isn't just about what allegedly happened in 2025. It's about the past stacking up. Here's the legal reality. When prosecutors prove multiple prior felonies, the sentencing range explodes. The courtroom tone even shifts. You can feel it. And now the real tension builds. Because a plea offer is coming. The question is, will he take it?
Of your life. Do you understand? And then finally, in cause number 25 DCCR 1778. Once we get all these done. You're charged with a third-degree felony offense of deadly conduct discharging a firearm from that same date of August 31st of 2025. It does allege those two prior felony convictions. Again, what that means, if you're found guilty and if those prior convictions are true, you would be considered a habitual offender in that case also, with a minimum punishment of 25 years, up to 99 years or life in prison. Do you understand?
Yes, ma'am.
In all of those cases, I have here on this tablet a plea bargain rejection in each case that you've signed with Mr. Parker that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty in your cases to go on. Probably it looks like counts 1 and 2 for a 15-year term instead of that habitual. And so in 2 of the cases, a 15-year term, and then in
It's 15 on all, concurrent on all of them, Judge. Yeah, because it's state jail is ahead of.
I opened the wrong one. Sorry. Hold on, y'all don't want me to do that. That's a 30.
Oh, that's my next one.
Sorry. Okay, so 15 years in all 3 cases that would run.
Okay, here it is, the moment of truth. 15 years. All cases. Concurrent. Let's break that down. Concurrent means he serves them at the same time, not stacked. Compared to 25 to life, that's a massive difference. This is what we call a trial penalty risk. If he gambles and loses at trial, the sentence could skyrocket. And listen carefully to the judge's warning. Once this goes on the trial docket, that deal likely disappears. No takebacks unless something major changes. So now ask yourself, is rejecting this confidence or a dangerous roll of the dice?
currently, which means together at the same time. Do you understand what the state has offered you?
Yeah.
And so you have every right to reject that offer and have all three of your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty in your cases. And do you understand all of that?
Yeah.
And do you want to reject those offers and have your cases set for trial? All right, we'll get that done. I do want to, is there any reason to believe that these offers would change?
Not at all, Judge.
So, Mr. Oville, I want to make sure you understand that after today, unless there is new evidence that is discovered by either your attorney or the state's attorney, I will not accept these plea agreements again. Once it's on the trial docket, it either goes to trial, you can plea open to the court or to some different amount or negotiated punishment. Do you understand? Okay, so I will get your cases set for trial. Mr. Oville, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you? Okay, so Mr. Parker, you're released. Mr. Oville, we will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Thank you.
Thank you.